The courtroom is silent, but the air feels electric. For months, the country has been watching as whispers turned into headlines, and headlines into a single question that could reshape the nation. Should Americans need government permission to exercise a constitutional right? When the Supreme Court agreed to hear the case, the shockwaves hit instantly. Within hours, news networks scrambled to interpret what it could mean. Analysts called it the boldest Second Amendment challenge in modern history. But for everyday Americans, the question cut deeper. If this ruling goes through, how would the country look the next morning? Across small towns and sprawling cities, people picture two different futures. In one, a law-abiding citizen simply walks into a store, purchases a firearm, and carries it without a second thought. No paperwork, no waiting period, no permit. In the other, law enforcement agencies and state governments warn of chaos, arguing that without regulation, public safety could teeter on the edge. It's a perfect storm of ideals colliding: liberty versus control, history versus modern fear. The case itself started quietly. A group of citizens, frustrated by what they saw as endless bureaucratic barriers, filed a lawsuit claiming that permits violate the essence of the Second Amendment. They argued that no other constitutional right requires prior approval. You don't apply for a license to speak freely. You don't pay a fee to go to church. Why, they asked? Should the right to bear arms be treated differently? Their claim wasn't about convenience. It was about principle. As the lawsuit climbed through the lower courts, something unusual happened. The debate refused to fade. Every ruling, every statement from a judge, every appeal lit up social media feeds and talk shows. Even those who rarely followed politics found themselves choosing sides. Then came the moment no one expected. The Supreme Court accepted the case under emergency review. That decision alone signaled urgency. The justices didn't want to wait years. They wanted answers now. Inside the marble halls, the arguments unfolded like a chess match. The petitioners painted a picture of the founding era, reminding the court that the early republic operated without modern permit systems. They cited history. How many of the first state constitutions used the word "shall not be infringed" without qualification? The opposing side countered that today's world is different, that public safety and modern weapon technology justify responsible regulation. But the central question wouldn't go away: can a right truly be called a right if it depends on permission? Outside the court, the reaction split the nation. Supporters of the challenge gathered in peaceful rallies, waving flags and holding signs that read "rights don't require permission." On the opposite side, protesters demanded stronger background checks and tighter rules, fearing that removing permits could open dangerous loopholes. The divide wasn't new, but the stakes had never felt this high. Every headline, every news clip seemed to echo the same sentiment. Something historic was about to happen. Legal experts began analyzing potential outcomes. Some predicted a narrow decision. Perhaps the court would rule only against specific permit schemes while allowing others to remain. But others believed this could go much further, creating a sweeping precedent that would redefine the relationship between the individual and the state. If the court declared that permits themselves were unconstitutional, every existing law requiring them would vanish overnight. States would be forced to rewrite their firearm codes from scratch. Imagine the ripple effects. Law enforcement agencies would have to rethink how they monitor firearm ownership. Training requirements, background databases, and local ordinances could all be called into question. Politicians would scramble to react, some celebrating the victory for freedom, others calling emergency sessions to pass new forms of regulation under different names. It would be a nationwide legal earthquake. In the midst of this, one question keeps surfacing: what happens when freedom and safety collide? The plaintiffs insist that individual responsibility will prevail, that citizens should not be treated as potential criminals simply for owning a tool of defense. Opponents warn that the absence of permits could make it harder to track firearms used in crime. Yet both sides agree on one thing: whatever the court decides, America will never see gun rights the same way again. Analysts also point to the political undercurrent. With elections approaching, candidates from both parties are watching closely. A ruling like this could energize voters across the spectrum. For some, it would symbolize the restoration of a fundamental liberty long restrained by red tape. For others, it would represent the dismantling of a system meant to keep communities safe. The decision would instantly become a defining issue of the campaign trail. As Decision Day approaches, even seasoned reporters admit they've never seen anticipation like this. Regardless of which way the ruling goes, it will shape the definition of constitutional rights for generations. The court's opinion will either cement the government's authority to regulate or reaffirm that permission cannot coexist with liberty. In either case, history will be written. And that's where the deeper reflection begins. What does it really mean to live in a country built on rights that cannot be taken away but can still be regulated? Where is the line between safety and control? Between personal responsibility and collective order? The hypothetical Supreme Court decision to end all firearm permits forces everyone to confront those questions. It's not just about guns, it's about the framework of freedom itself. If the court were to strike down all permit laws, America would enter uncharted territory. Some states might embrace it, claiming it restores trust between the government and the people. Others might scramble to introduce new measures, renaming permits as safety verifications or training certification. Legal experts predict that any such workaround would immediately face new challenges, sending the issue back into the courts again and again. Through it all, one truth remains: constitutional interpretation is not static. It evolves with the times, shaped by new generations who view liberty through their own lens. The conversation around this case, whether real or imagined, shows how deeply Americans care about their rights and how fiercely they will debate the boundaries of freedom. As the final moments of the hypothetical hearing close, the Chief Justice thanks both sides, gavels the session, and the crowd rises. Outside, reporters rush to deliver breaking analysis. Protesters cheer, others shout in disbelief, and the cameras pan across a nation holding its breath. Everyone knows that the next announcement could alter not just laws, but the very relationship between citizen and state. Weeks later, when the decision is finally released, the world pauses to read the headline. Whether the ruling affirms permits or abolishes them, one message resounds through the entire debate: the question of freedom is never settled, it is continually tested, argued, and redefined. And that is the essence of the American experiment.